5 seconds to go. Start. In light of this and the aforementioned draft rule 4, this court went on to hold in Manoj that, in view of the above discussion, this court holds that the prosecution, in the interest of fairness, should, as a matter of rule, in all criminal trials, comply with the above rule and furnish the list of statements, documents, material objects, and exhibits which are not relied upon by the investigating officer. The presiding officers of courts in criminal trials shall ensure compliance with such rules. In addition to the decision in Manu Sharma as noticed in Manoj, there is another decision, Manjeet Singh Kheda versus State of Maharashtra, which had highlighted how the requirement of disclosure is an intrinsic part of the right to fair trial under Article 21 of the Constitution. Relying upon its previous decision in VK Shashikala vs. State, this court noted in Manjeet Singh Kheda. In that case, the documents were forwarded to the court under section 173(5) CRPC but were not relied upon by the prosecution, and the accused wanted copies inspection of those documents. This court held that it was incumbent upon the trial court to supply the copies of these documents to the accused, as that entitlement was a facet of just, fair, and transparent investigation trial and constituted an inalienable attribute of the process of a fair trial which Article 21 of the Constitution guarantees to every accused. We would like to reproduce the following portion of the said judgment discussing this aspect. The issue that has emerged before us is, therefore, somewhat larger than what has been projected by the state and what has been dealt with by the High Court. The question arising would no longer be one of compliance or non-compliance with the provisions of Section 207 CRPC and would travel beyond the confines of the strict language of the provisions of CRPC and touch upon the larger doctrine of a free and fair trial that has been painstakingly built up by the courts on a purposive interpretation of Article 21 of the Constitution. It is not the stage of making of the request, the efflux of time that has occurred, or the prior conduct of the accused that is material. What is of significance is if, in a given situation, the accused comes to the court contending that some papers forwarded to the court by the investigating agency have not been exhibited by the prosecution, as the same favors the accused, the court must concede a right to the accused to have an access to the said documents if so claimed. This, according to us, is the core issue in the case, which must be answered affirmatively. In this regard, we would like to be specific in saying that we find it difficult to agree with the view taken by the High Court that the accused must be made to await the conclusion of the trial to test the plea of prejudice that he may have raised. Such a plea must be answered at the earliest and certainly before the conclusion of the trial, even though it may be raised by the accused belatedly. This is how the scales of justice in our criminal jurisprudence have to be balanced. It is true that this court in VK Sasikala Supra was dealing with material documents that were forwarded to the magistrate under section 173 CRPC but were not being relied upon by the prosecution. However, it is undeniable that there could also arise a situation wherein the investigating officer ignores or does not rely on seized documents, material or evidence which favors the accused and fails to forward it to the magistrate as required under section 173 CRPC, specifically subsection 6. Merely because it is not already on the record of the court cannot disentitle the accused from accessing material that may have exculpatory value. It is this gap that was recognized and addressed in the suo motu proceedings and suitably codified in the text of the draft rule 4 by introducing a requirement of providing a list at the commencement of the trial of all documents, material, evidence, etc., seized during the course of investigation or in the possession of the prosecution, regardless of whether the prosecution plans to rely on it. The facts in Manoj having reflected such a situation of suppression of evidence that favored the accused similarly necessitated elaboration of this right. The framework that emerges by reading section 173, 207, 208 and draft rule 4 is that based on the list of statements, documents, etc. received at the commencement of the trial, the accused can seek appropriate orders under section 91 of the CRPC, wherein the magistrate on application of judicial mind may decide on whether it ought to be called for. Additionally, by virtue of section 391 of the CRPC, the appellate court, if it deems necessary, may take further evidence or direct it be taken by a magistrate or court of sessions upon recording reasoning. This safeguards the right of the accused in a situation where concern has been raised regarding evidence or material in possession of the prosecution that had not been furnished but was material to the trial and disposal of the case. Stop.